Okay.
Okay, the meeting of the Rent Control Board is called back to order after the closed session. Please join me in our salute to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, before we move into the report from a closed session, I wanted to move item 14 on the agenda to after item 10. So it would be between item 10 jurisdictional items and item 14 item 12 administrative items. So we would discuss the algorithmic rent software before we would discuss the notification of disclosure of construction. If anyone, if there's no opposition to that, do we do a voice vote or just?
You could just show of hands.
Okay.
If everyone's in favor of that.
What's that? We'll move to that next, but I just wanted to deal with the agenda first. Is there any opposition to moving those to the order of this agenda items? Okay. Thank you. Okay, so moving on, would General Counsel please report on the closed session?
Thank you, Chair. Good evening, Commissioners. The board met in closed session at 6:07 PM and adjourned at 6:55 PM with no reportable action taken. And that concludes my report. Thank you.
Thank you. Moving on to item 5, the approval of the minutes. If commissioners have had an opportunity to review the minutes from our February 13th, 2025 meeting, May I please have a motion for their approval? Commissioner Leslie?
I move that we approve the minutes.
Second.
Okay, moved by Commissioner Leslie and seconded by Vice Chair Ivanov. And can we have a roll call, please?
Commissioner Ambrose,
Yes.
Commissioner Dudek,
Yes.
Commissioner Leslie,
Yes.
Vice Chair Ivanov,
Yes.
Chair Gonska.
Yes.
Okay.
Okay, next up on the agenda, we have the special agenda items. Do we have anything from the Executive Director to report to the board?
Yes, thank you, Chair. And good evening, Chair, Vice Chair, Commissioners, and members of the public joining us tonight. If any member of the public is concerned about price gouging, knows of it taking place, or believes they are a victim of price gouging, the City Attorney's Office maintains an FAQ at www.santamonica.gov/price-gouging. There are also links at the site to file a complaint. Complaints may also be filed with the Attorney General's Office at oag.ca.gov/report. On February 25th, 2025, the Los Angeles County Board of Supervisors voted to enact the resolution to provide tenant protections from February 1st, 2025 through July 31st, 2025. The resolution applies to tenants countywide, including incorporated cities such as Santa Monica. The resolution enacts temporary eviction protections for qualified tenants facing eviction for non-payment of rent due between February 1st, 2025 and July 31st, 2025, as a result of the recent wildfires and windstorms in LA County. A qualified tenant must meet the following requirements. 1, have lived in the rental unit since before January 7th, 2025. 2, have earned a 2024 household income equal to or less than 150% of the area median income. And 3, have begun, quote, income replacement efforts, which means enrolling in or applying for a relief program for county wildfires, unemployment benefits, or other qualifying income assistance, or be actively seeking employment. More information on this program can be found at dcba.lacounty.gov/rent stabilization. Thanks to a California Department of Aging, Local Aging, and Disability Action Planning grant, and with support from the AARP Network of Age-Friendly States and Communities, the city is creating its own age and disability-friendly action plan to address the current, emerging, and future needs of Santa Monica's older adults, people with disabilities, and their caregivers. The needs assessment phase of this project is kicking off this month with 2 key activities that will enable community members to provide their input on how we can make Santa Monica an even more age and disability-friendly community. A community survey launched February 24th will remain open through April 1st. Surveys will be available in multiple languages, available to complete online or via a paper version available at designated locations throughout the city. Full details are posted on the project website. The community is also invited to participate in an in-person open house at Santa Monica College Emeritus campus on Saturday, March 22nd from 9 a.m. to 12 p.m. Virtual participation will also be available for those unable to attend in person. The project team will analyze the results from the community needs assessment activities and will work with the Action Plan Advisory Committee, which was formed in October 2024 to inform the city's Aging and Disability Action Plan. The action plan will be presented to the City Council in September of 2025. For more information, you can visit the city's website, the Aging and Disability Action Plan, or by emailing humanservices@santamonica.gov. While both rent control regulations and state law limit the amount that property owners may collect as a security deposit, the return of the security deposit is governed by state law, and there is an important new requirement for landlords beginning next month. Starting April 1st, landlords must take photographs of vacated units a reasonable time after gaining possession, but prior to any repairs or cleanings for which the landlord plans to make a deduction from the security deposit. Photographs are also required within a reasonable time after such repairs or cleanings are completed. This documentation is intended to help resolve conflicts over amounts withheld. Tenants disputing the return of the security deposits are encouraged to write a demand letter to the landlord, and if not satisfied, may file an attempt to recover in small claims court. Tenants and landlords can find more information about security deposits and deductions in a publication on our website called California Tenants, which can be found on the board's information by subject webpage. Finally, I'd like to thank Commissioner Dudek for bringing to my attention that the Santa Monica Conservancy is partnering with Pacific Palisades Historical Society to present an afternoon live stream event on March 16th at 5 p.m. celebrating the history of the Pacific Palisades with 4 community leaders who will reflect on the region's rich heritage, share fond memories of life in their cherished village, tell of the devastating loss in the Palisades wildfire, and describe their hopes for recovery. Hear how these leaders have impacted their community and how you can support the heritage of Pacific Palisades. To obtain the link, Google Santa Monica Mosaic, The Way We Were, and click on Shared Memories of a Lost Village. That concludes my remarks.
Thank you very much. Moving on, next agenda item is public comment, and this is time for the public to address the board on any topics that are not on tonight's agenda, but that are within the board's subject matter jurisdiction. And we just note that we cannot take any action on these items tonight, but we're anxious to hear from the members of the public. So I have 3 speakers who have signed up. If anyone else would like to request to speak tonight, you can see the secretary here. But I will call the speakers in order here, and you'll have 3 minutes to address the board. First up, we have Zoe Manser.
All these documents I sent to Mr. Portillo, so you can have access and they're on the record. My name is Zoe Montaneras. Some of you already know me. I spoke on Tuesday at the City Council meeting on items 11A, 16G, and 16H. They were related to rent control and protections. And unfortunately, I had to share with the City Council that the Santa Monica Police Department officer, Stephen Hollowell, shared with me that the city attorney, who is supposed to uphold and prosecute people who violate the law in Santa Monica, gave direction to them and gave direction to the Code Enforcement Department not to file fines or charges against the landlords that were harassing me. This is a scandal because this is the guy that is supposed to enforce the law. But when you have the main guy that is supposed to enforce the law giving directions to 2 different departments that are supposed to protect renters, we have a serious problem. I took a class on January 7 with Judge Jurna and Judge Broadbelt with the LA Law Library to talk about the increase of incivility in the practice of law and public discourse, discussions between counsel and litigants playing hardball, making life difficult to the other side, incivility driven by bias. And that is what is happening in Santa Monica. And we have a lot of campaigns about civility and a lot of campaigns and talk about compassion, but the bias here, it is so evident that in the previous meeting, I asked Douglas Sloan to look at me when I'm speaking, and he refused and he was looking at his phone. And Council Member Natalia was so taken aback that she started looking at everybody else. And nobody said, she's a resident, she's a constituent, look at her because she asked you to look at her. Obviously, he was not looking at me because he knew what he was doing against my back. So he was playing both sides. He was playing the Santa Monica Police Department, he was playing me, and he was playing code enforcement. You need to address this because without protections, we can have laws, but if nobody is enforcing them, we're not making any progress and we're not moving the needle. So I would like to ask Council Allison Regan to send me a letter to tell me what is the status of the claim.
Okay, thank you. Next speaker we have tonight is William Kyrella. Good evening.
Can you hear?
Yes, we can. Thank you.
Okay, good. What I have here is being a Santa Monica resident for more than 30 years, I've been through the rent decrease petition a few times, and I'm fully acquainted with it. And what I'm asking you guys is the process, the rent decrease petition, is the only tool that we tenants have to avoid being taken advantage for the property managers, for the landlords. And that process is outdated. It's cumbersome. It's against to achieve what it was intended to do. The intention when it was created was not to penalize landlords, it was to discourage them to take measures to take advantage of the tenants. It was designed with that purpose. Well, nowadays that purpose is being erased because the process itself. I'm going to mention two things here. In the process, I believe that even landlords will approve an update of the process because there are a few reasons. One, it will save time. It will save labor involved, people involved in the process from the city. Resources, money, it will save money because landlords don't want to go through the penalties. It's painful for them. The rent in Santa Monica is under control. They're not happy with it, but they're okay with it. If on top of that they have to pay penalties, they don't like that. If you make this process more efficient, and it can be, and I did propose volunteer my time, and I was diplomatically ignored because the process has to be within the framework of the law. The process is not because I think or I believe or I would like to. No, it has to be within the framework of the law. And for that, I need the help of the rent control department, but not when I'm pushed away.
Okay, thank you very much. Our next speaker we have tonight is Amy Gottstein. And you can come to the microphone and you'll have 3 minutes to address the board tonight. Oh, you just want 2 minutes? Sorry, correct, yes. So you'll have 2 minutes.
I think I'll start with just regular public comment.
Yeah.
So, good evening, everybody. I have a wish list, actually. I did share these items with Chair Gonska and Vice Chair Ivanov, and so I'll just repeat those here. Several documents from the Rent Control Office state that they are signed under penalty of perjury, but there is no penalty, and they perjure them all the time. So I'd like to see some mechanism for actual enforcement on that, especially if somebody can prove it. I also don't believe that if somebody proves perjury, for example, on owner registration or tenant registration, that they would need to file a non-registration petition in order to prove that something was perjured. So that's one of my wish list items. I also am finding that owner addresses on ownership registration forms are phony because they are disguising P.O. boxes with the street addresses of mailbox type stores. I see that a lot in the public records, and I would like not to see those. Another one is a wish list for the document portal, is that some of the documents are, you can do a search by parcel number or by address, but the search results are not the same. And I have the wish list that no matter which search somebody performs, that they find the same exact set of records there. And also, when there's a new owner who, say, has never owned before, I would like to see that there's some kind of flagging to the finance department to ensure that they get a business license. I am finding a lack of connections within the department, and business licenses are required. I'd also like to see some kind of business license for landlords who rent out garages or parking spaces separate from residential leases. So that's it for my public comments. And on to 14G, I couldn't be more thrilled that Chair Gonska has raised this in partner with council to ban algorithmic price fixing. Of course, it bilks people out of money. It's totally unfair, and we're already facing price increases just buying groceries and things like that. So I was alarmed when I first learned about this, and I look forward to that. I guess it's a little bit of a cautionary tale because
You can finish your thought there, your sentence there.
I can keep going.
Well, just to finish that last thought, I didn't want to cut you off mid-sentence.
I was told, my apologies.
Did the clock not reset?
Sorry.
Should we do 2 minutes because she's speaking on 2 items?
So was it an additional 3?
Oh.
Okay, yeah, that's fine. That's fine. You can continue. Sorry for the disruption.
It's okay. I did try to check on this, and anyway, it's totally fine. But my primary concern is that it's hard to know, right? Because the landlord isn't going to volunteer that they are utilizing this type of price-fixing software to set rents. And they're certainly not going to admit to it either. So I just urge you to be extra cautious, whether it's a regulation for this or anything else, because landlords are also very good at wiggling out of things or skirting issues or finding an inroad to this. And it's also not just RealPage. And I did talk to Chair Gonska about this, that there's another software program that the smaller players use here in this city called Yardi, which is, there are also lawsuits about that. But RealPage is the one more for market rate properties because they're corporate landlords, but not for some of the smaller properties. And I was mentioning that I have seen that as a preferred skill in like help wanted ads for property management companies. So I just urge you to try to consider all of the ways that a landlord could wiggle out of it, and also try to find out a way of how to distinguish if it is being utilized or not. And I don't know how that's done, but I will trust that y'all figure it out. Anyway, thank you so very much.
Thank you very much. Okay, so that concludes our list of public speakers for this section of the agenda. So we'll move on to item 10, jurisdictional items. And 10A1, the first item is owner occupancy exemption application regarding 2807 Pearl Street. And may we have a staff report, please?
Certainly, Commissioners, good evening. The applicants are Brian Stedge Stroud. There's a misspelling at the end, it should be a U. And Alexander Comboy. They bought this 3-unit property back in July of 2024, and they moved on to it after they purchased it, and they've applied for its exemption. They're the sole owners of this property, and the property only contains 3 units, so it meets the minimum percentage ownership and the unit criteria for the exemption. So the question is whether they have provided sufficient evidence to show that they've lived on the property since August 22nd, 2024, which is 120 days before the filing date of the application. Ms. Comboy does own a condo in West Hollywood, but she provided a lease to show that it's rented and that she doesn't live there. They provided utility, financial, and government records to show that they've lived on the property for the requisite amount of time. And the staff sent the rented units in the property, tenant response forms. One of them returned it and said that they do live on it. The other one did not, and so we sent the hearing investigator to the property, and the hearing investigator's report is consistent with the claimed occupancy as detailed in the staff report. And for those reasons, we recommend that you grant the exemption application and adopt the attached findings of fact and conclusions of law.
Thank you. And Commissioner Ivanov, I see you in the queue here. Do you have a question about the staff report? No. Okay. Are there any questions for any commissioners specific to the staff report? Okay. Then we can begin deliberation. Commissioner or Vice Chair Ivanov.
I would move that we adopt the findings of fact and conclusions of law.
Do we have a second?
Second.
Okay. Okay, motion by Vice Chair Ivanov and seconded by Commissioner Ambrose. Can we have a roll call vote, please?
Yes. Commissioner Ambrose,
Yes.
Commissioner Dudek,
Yes.
Commissioner Leslie,
Yes.
Vice Chair Ivanov,
Yes.
and Chair Gonska.
Yes.
The motion carries.
Okay. So item 10B1 is being continued to our April 10th meeting. So moving on to item 10B2, decrease petition. This is an appeal in a decreased case regarding 1033 11th Street, Unit D. May we have a staff report, please?
Commissioners, Saudi Sanchez, who is a tenant of Unit D, filed a rent decrease petition for various alleged maintenance conditions and reductions of housing services. The hearing officer granted her decreases totaling $75. Her rent was $2,204 prior to the decision. She has appealed that decision. She argues that she should have received decreases for alleged mold contamination in her garage. She alleged that a mold contamination company hired by the owner tested and found elevated mold spores in the garage. But the hearing officer noted that she did not provide evidence to corroborate her testimony. She did not subpoena the owner for results of the alleged mold test, and she did not provide any other evidence that corroborated mold contamination in the garage. And the landlord actually said that there was no such testing of the garage. Based on the evidence provided, the hearing officer found that she failed to meet her evidentiary burden, and the record reasonably supports her finding. Ms. Sanchez also argues that she should have received decreases for alleged mold contamination in her second bedroom, but that condition was not listed in her petition. Therefore, it was not eligible for consideration in the petition under the board's regulations. Ms. Sanchez also complained in her appeal about the landlord's failure to repair the washer-dryer, but the hearing officer did in fact grant a decrease for that condition, and that decrease shall remain in place until that condition has been abated. Ms. Sanchez also argued that she should have received decreases for malfunctioning blinds in her second bedroom, but as detailed in the staff report, she already had received a decrease for this condition in her previous petition, and that continues to be in effect. And Ms. Sanchez also argues that she should have received past decreases for her conditions going back to when she returned to her unit, but the hearing officer granted past decreases in accordance with the regulation, which is to the first rent date due after the filing of the petition, and that's exactly what happened here. Because the hearing officer's decision is supported by substantial evidence and reasonably supported by the record, staff recommends the board affirm the decision and its findings of fact and conclusions of law.
Thank you. Do we have any questions from commissioners about the staff report? No? Okay, we do have a request to speak from the appellant, Saudi Sanchez. So if you'd like to step up to the microphone here. And you'll have 5 minutes to address the board when you're ready to begin. And just one note, we can only consider things tonight that were included in the appeal, in the original petition and the original hearing. So please just limit your comments to things that were addressed during that process.
Yep. So the original petition was actually filed, and I went to a hearing on September 24 of 2023 with the board. I vacated the premises in August of 2023, was not able to return to the unit until May of 2024. The landlord was not granted a habitability certificate until April of 2024 because the whole unit had to be demolished due to mold contamination. There were various mold reports and other reports that were both paid by me and paid by the landlord at the time. In June of 2020, I began renting the garage in May of 2019. In June 2021, there was the first situation happening with the mold in the unit, and at the time, the unit was managed by Sullivan Deturi. I was granted the deduction of that $200 per month because what was stored in that garage was actually contaminated property. I've moved in and out of the unit a total of 6 times, 3 full move-outs, relocations. The last relocation was 7 months. During the time that I was relocated for that last relocation, the last major relocation, the garage was included as part of the demolition and as part of the decontamination. When I returned to the unit in May, the garage was locked. I had no access to it. I had already provided access for them to do the remediation. And I returned to the unit and the garage was locked, not remediated. And the landlord, or the property management company, MF Property, said that they didn't have any idea that what they were supposed to do with the garage, although I had met with them, provided both the management company owner and one of his contractors keys, and left with instructions and continuously emailed during the time that I was away, requesting as to whether the garage was ready. When I returned and actually booked the relocation, I did not have a response, so I ended up bringing movers in and began to move things into my unit. Now, the things that I could not, that would normally fit in the garage, which included bicycles, surfboards, etc., ended up in my second bedroom. Again, I could not move them out of there. In addition to that, the MF Property Management kept the utilities, the appliances that were contaminated and were supposed to be left out of the apartment, and they brought them, not only did they leave them in the unit during construction and mold remediation, but they also returned them back to their place and did not replace those appliances until I had to come back one more time here. And this was already something that was an issue in September. So I had to come back one more time and do another hearing. And actually, I was booked for a mediation, and during the mediation, the mediator started giving me legal advice, which is illegal for a mediator to actually do that. The call was also disconnected. I was not able to get back on, so I had to book a second portion of that mediation, at which point I had already been requested I had a hearing because the mediations in your office are not recorded. I also came back in May and June, and the decision for the September 23rd hearing had not been issued yet by your office. I kept returning to your offices. I spoke with people in your staff. I actually requested a meeting with Jonathan Hubbs several times and left messages in his voicemail. Never had a response to that. As of right now, I have an actual formal complaint in a lawsuit filed against the landlord and the management companies, both management companies, Sullivan Deturi, which managed the building from 2012 when I began my tenancy, and it stopped in May of 2023. Almost missing the statute of limitations, and then at that point, MF Properties took management of the building and began to mismanage the building in the same fashion that Sullivan Deturi had done, and is well known for doing so. As of right now, actively since June of 2021, which is when the mold contamination began in the garage, I had not been able to use that for the intended purpose. I had also invested $700 of my own money to sheetrock that garage and paint it prior to those dates. So essentially, in 2021, I had no use for 6 months. 2022, I had no use for 12 months. 2023, another 12 months. 2024, 12 months. And 2025, 1 month, because the garage was finally remediated back in January. So essentially, in February, it was when they finished. I had to move out one more time out of my unit. And I was out of my unit from February 2nd. I was supposed to be only out of there until the 8th because yet another water issue had come down from the unit above me into my kitchen. And I was out of there for actually 12 days. Essentially, $200 times 43 months is $8,600 that have come out of pocket for an amenity that I did not have used to. That's not even counting the fact that during the 6 months from the relocation back into the unit from May 6th until the actual remediation, which just happened in February, I had 6 months or longer than 6 months of no use of that second bedroom, which is where I had to then store. Not only could I not rent the bedroom, but I also had no use of that space and had to store those things into the second bedroom until I could move them into the garage. I've returned to the office. Copious amounts of time have dealt with your staff, and I found the process to be cumbersome frustrating and ineffective.
Okay, thank you for your comment. Do any commissioners have any questions for Ms. Sanchez? I do have one question. I know in the petition, there's one of the issues is the washer and dryer. And I think in the report here, it says that either the building owner or the property manager said that they're already contracted with a company to maintain and to fix that. Has that been addressed to this
That
today?
was addressed on the 5th of this month.
So it has been addressed today, but just,
As of the 5th of this month. So essentially, since it was reported, which was, I actually reported that back when Sullivan Detroit was still managing the building, and it has been in various petitions that I've made to the Santa Monica Rent Control Board, and that was not actually fixed until now. So
Okay.
it's basically 4 years of that.
okay, thank you. Are there any other questions for Ms. Sanchez? Okay, thank you very much for speaking with us tonight. Okay, do we have any commissioners that would like to begin deliberation? I do have one comment I'd be curious on others' thoughts on that. I know that one of the issues here in the appeal was that, was the decrease amount for the laundry amenity. And in the, let me find my place here. It's, we have a report here that there was a decrease of $75 awarded for the reduction of the amenity. But it was noted here that, sorry, let me find my place. That the amount of $75 was selected, quote, because all four machines are in poor working condition. However, they're not completely inoperable. However, another part of the record states that the dryer actually, at least one of the dryers actually appears to me to be inoperable, that you have to put clothes in for multiple cycles and they still don't entirely dry the clothing. So I'm a bit confused about those seemingly contradictory elements, and if there is some validity to an argument for that was not an appropriate reduction for that amenity. Commissioner Ambrose.
My comment doesn't relate, so.
Okay. I guess a question for staff then would be, is that within our jurisdiction to take action based upon that, like a contradiction within the report about the stated reason for the dollar amount being selected that appears to be contradicted by other parts of the record?
Is that part of the appeal? If it's not part of the appeal, then it's not something you can consider.
I thought that there was a part of the appeal was to do with the laundry facilities.
The washer dryer, in the appeal, it says the washer dryers have not been replaced or repaired to date. Today is January 31st, 2025. So that's what was included in the appeal.
Okay, so it was that they hadn't been replaced or repaired, not, it wasn't specifically appealing the dollar amount of the decrease. Gotcha, okay. And then one other comment just wanted to make on this was that there was an issue of mold in a second bedroom that was brought forward in the appeal, or no, I think it was the original petition, correct?
It was mentioned in the appeal, but it was not indicated in the petition, and therefore it was not eligible for consideration in this process.
Gotcha, okay, so just wanted to make a comment that while it can't be considered here because it wasn't part of the original petition, in theory, it could potentially be brought forward in a new petition. Obviously, there's a lot of discussion here as part of this record about needing to provide evidence for mold existing, so I would just note that that's a crucial part of any ask of rent reduction for mold, but it can be considered to bring that forward in a different petition if there is evidence of that issue. Okay. Commissioner Ambrose.
Yeah, to that point, a question, how does one provide evidence of molds, for example, in a garage? Does a tenant call a mold company and have one come out and test for mold and then submit that as evidence? But how does one provide proof that there's mold?
it would have to be evidence that, for example, if there is a report of some elevated spores, then there would have to be also somebody who would be able to interpret those things to the hearing officer, either somebody from the company itself or somebody who the tenant brings, but who's an expert in explaining, well, what these numbers may mean. And then based on that, evidence similar to that, then that could be considered as evidence that there may be mold contamination and that it would be eligible for a decrease.
What's the standard for that in terms of like a level of professionalism? For example, I know you can go to like a Home Depot or an Ace Hardware and you can get these little at-home testing kits. They're fairly inexpensive. Does that satisfy? I think you could send them to a lab if you want them to be extra certified. Is that
I can jump in if I will. You know, any kind of mold test, the problem with mold and making a determination factually is that there aren't standards, regulatory standards for it. So somebody would have to come in and that's an expert and tell us what it means. I don't think that doing a home test would suffice, as it's not being done by a licensed professional who can then interpret the results. Nor could we ensure that it was done properly for the same reasons. But additional evidence, in addition to what Mr. Mordezai talked about, would be habitability determinations made by code enforcement or even county health department does mold inspections on, for houses. So any kind of notice of violation or correction that would be, would also be taken as evidence. So
I guess an example for in this case, if the tenant wanted to show that there is in fact mold in particular in the garage, the tenant would need to call code enforcement to test specifically the garage.
Based on my knowledge, code enforcement doesn't test. They don't do any testing.
So how would the tenant prove that there is mold in the garage?
I guess it's kind of a vague question because mold in the garage, there's mold everywhere. It's in the air. So is the mold that's in the garage something that can be abated by the landlord? Is it in the walls? Okay, the landlord's in charge of the walls. So if it's in the walls and it can be proven that, the structure itself is contaminated in some way, then perhaps. But if your personal items are contaminated with mold and then you put them in the garage, what does the landlord, what does compliance look like on our end in terms of, the landlord doesn't have any purview to move your items. So it's, mold is difficult.
Okay. Thank you.
But it's by no means, we're not the end-all be-all of a tenant's ability to get any kind of compensation or anything like that from the landlord if there's mold and they have compensatory damages.
Right. Thank you.
Commissioner Leslie?
So then, to ask another question, would not the County Department of Public Health could be called for that type of testing?
To my knowledge, they don't do testing either. What they do is based on a visual determination of does it look like an organic growth that is consistent with mold, and that's it.
Thank you.
Okay, Commissioner Dudek?
Yes, I'd like to know what code enforcement's role is, because I have heard of a case where they determined, if this is correct, that the mold did not meet a certain standard. What is their role in this area?
Yeah, I could speak to their exact parameters. I do know that in maybe the past year, they have increased their breadth of what they will consider looking at in terms of mold. Previously, it was just LA County Health Department. but we'd have to specifically ask them.
Go ahead.
I have another comment regarding the $75 for the washer and dryer. And that also was partly determined, is partly determined by the rent, the proportional. That's another, part of the equation I want to mention.
Yeah, absolutely. That's a
Yeah.
good point. And I think it's always helpful in the hearing officer reports when they give detail about how they come to that conclusion. I know this is a topic we've talked about several times in past meetings. And in this case, the hearing officer did specify how they came to that $75 for the laundry. You're absolutely right that it needs to be proportional to the overall rent being paid. But to have more specificity about how they determined a dollar amount is very helpful, both to the parties involved, to the public, and to the commissioners. I think I can speak for all of us with that. Are there any other comments or questions as part of deliberation? Is there anyone who would like to make a motion on this appeal?
I'll make the motion.
Okay.
And just a quick comment before. It sounds like the tenant has gone through a very lengthy process, and it's very unfortunate, the situation that the tenant is in here with, all these relocations and repairs that need to be made. Here, the hearing officer, I can't say that I disagree with their findings in that I find them reasonable, and that is the standard that we're held to. And I would like to say that this body is not the only place for the tenant to find their remedy. And it sounds like the tenant has already begun the process of seeking another remedy, so I'm glad to hear that. So I will make a motion to affirm the decision at 1033 11th Street and to adopt the findings of fact and conclusions of law.
Okay, do we have a second? Okay.
I second it.
Okay, we have a motion by Commissioner. Okay. We have a motion by Commissioner Ambrose and a second by Commissioner Leslie. Can we have a roll call, please?
Yes. Commissioner Ambrose,
Yes?
Commissioner Dudek,
Yes.
Commissioner Leslie,
Yes.
Vice Chair Ivanov,
Yes.
and Chair Gonska.
Yes.
Motion carries.
Okay, and then moving on to item 14, board discussion items. We'll come back, as we discussed earlier, to administrative items. But we have item 14 is actually my request to the board to consider a recommendation of the city council regarding regulation of algorithmic rent setting software platforms. We had public comment on that earlier today, and it's something that I mentioned an interest in last month as well at our meeting. So I think most of you, if not all of you, are aware of this software. RealPage is the most cited example, probably the biggest player in this area, but there are, as was stated during public comment, there are many other companies that do the same thing. And essentially what this is this is software that building owners can input basically proprietary non-public information about their renters, how much their renters are paying, information about their units, and the software aggregates that information across all the inputs from all kinds of different building owners in a region, in a city, in a jurisdiction, and recommends to those landlords what they should list a vacant unit, what price they should list a vacant unit at. And it also recommends all kinds of other information, like if they should leave a unit vacant, if they should, how long they should leave it vacant for. And essentially what this is all intended to do is to maximize the price that they can charge for the rental property, which puts upward pressure on prices. And it's basically a collusion. They're basically separate business entities that are sharing information with each other in order to collectively set rent prices, which is pretty clearly, in my mind, already illegal. But as we can see with all kinds of issues, the sort of legal process is slow moving. And while that process plays out, which can take many years in some cases, tenants are being negatively impacted by artificially increasing prices. So there are several lawsuits around the country pending right now against this type of software usage. The U.S. Department of Justice has a lawsuit that 10 other states, including the state of California, have joined. The city and county of San Francisco banned the use of this type of software late last year. And so I think we need to discuss how it's impacting our constituents here in Santa Monica and what our potential remedies are to combat this, in my mind, illegal use that's driving up prices for tenants. And one other thing I'll note too, that during our wildfire emergency that we're currently in here, we obviously all have seen reports and charges against some landlords for price gouging. And what's been interesting is that actually in response to those allegations, some landlords have actually testified or at least explained that the prices that they've set that are above the 10% limit and that constitute price gouging were actually recommended by this very type of software. So this software is taking advantage of people during times of emergency when they're very vulnerable. So I think there's a few things that we could potentially do about this. One, I think most of the jurisdiction, certainly in terms of potentially banning the use of the software in Santa Monica, falls to the city council. So we could certainly have discussion and make recommendations or asks of the city council in that regard. And actually, this week at their city council meeting, they did direct the city manager and city attorney's office to come back to them, I believe within 60 days, to potentially ban or address the use of the software in Santa Monica. And I also have had some discussions with our staff about what within our authority we could potentially do. And there's some conversation or thought about any potential regulations that we could consider to require disclosure, for example, if this type of software is being used. So that's generally, I think, what I'd like to bring to your attention here tonight, and would certainly be willing to entertain a discussion or any questions. So Commissioner Ambrose.
Thank you, Chair. Thanks for bringing this to our attention. I think it's a good thing for this board as a body to discuss and also to just make very clear that we all are in agreement that we dislike this software. I think that it does negatively affect our constituents, and the more that we can regulate and make sure that our prices are not inflated artificially, and that we are making sure that things are fair across the board, the better. So I think that this is great and fully support that.
Commissioner Leslie.
I'm in support of looking into this, but as well, I know this is not in our purview, but things to consider just for, public record. As our fire victims are displaced and are staying in hotels, how they are also experiencing a 500% markup in the hotels as well. So they're being pinched on both sides, from the hotels to the temporary housing that they obtain where they're using this software. We have to do better for our constituents, and we have to do better when people are in need. This is what drives people into homelessness. Those are my comments.
Vice Chair Ivanov.
So this is kind of more of a procedural question, and I'm going to ask staff how this is going to look like as well. But so you mentioned it seems like the wheels are kind of already in motion in terms of the city manager and the city attorney's office are tasked with putting together a report within 60 days. Was that the last council meeting that happened this Tuesday?
Yeah.
Are we able to ask somebody from the city attorney's office to come to our next meeting to so that we can consult while that report is being drafted, instead of us just seeing the final result and then saying whether we recommend it or not?
Yeah, I mean, I think part of the direction was to come to the board with their proposal, and so you will have an opportunity to weigh in on what they are working on.
So before this gets to the council, we'll have an opportunity to weigh in before the report gets there?
Yes.
Okay, great.
I don't actually remember, I admittedly don't actually remember, but I don't know, was it part of the city council's vote to require consultation with the board on this issue? I might have to, I don't know if it actually was. It might have to go
Yeah,
back.
I thought that everything that they were talking about with respect to tenant protections, I thought they were directed to make sure they run it by the rent control board.
Okay, yeah, certainly other parts of that, it was definitely part of the conversation, but I
Right.
think these things were two different agenda items
If
with the
that's
tenant
the ca-
protections.
I mean, I can certainly go to the city attorney's office and ask them to come to the meeting, and I think they would be fine with that. I can't imagine anyone objecting to getting your input before they go back to council.
Okay, yeah, I might be wrong. You might absolutely be right that they did require consultation with the rent control about it, but one way or another, to your point, I think it would be good to, whether that's a formal requirement or if we just ask for them to do it, I think the end result, we would all, or at least we would like to see. Okay. Commissioner Dudek?
Yes, I just, I want to thank you for making your presentation at the board meeting, at the city council meeting on this issue. And I think this is a great step forward.
So.
We all do. Thank you.
Absolutely. So I don't think, is there any other action that we need to, if we wanted to, next meeting or in the future, bring any sort of recommendation or explore, if we want staff to explore potential regulations that we could, because part of the issue is it does seem like the city council is keen to move on this issue, potentially banning it. However, we don't know when that might happen. We don't know their legal authority to do that. We don't know if for certain that they will do it. So in the meantime, as I mentioned, as legal process both here and other places plays out, this software is being used today and it's impacting tenants today. So we may still want to look at what our authorities are within our regulations to require disclosure or any other ways to do that. So do we need to do anything here tonight in order to have the ability to bring that in future meetings?
You can direct me to work with the city attorney's office on this proposed ordinance and also to look into whatever type of regulations we can implement. In the meantime, if there is a meantime, I suspect that particularly on this piece, the city attorney's office is going to move pretty quickly. So I anticipate that they're going to come back to the city council fairly quickly, but you can still direct me to also do some work on this subject, and you can do that by a consensus vote.
Okay. Vice Chair Ivanov?
And at the time when we have that presentation from the city attorney's office, at our next meeting, the April meeting, is that enough time for you to also, by that point, figure out what regulations we could potentially amend, or is that not enough time for you?
I think that would be enough time. And then if I need more time, I can let you all know.
Okay. I think that would be efficient if, when we have the presentation on the same day, we have an idea of what regulations we can change so that we can move on it swiftly instead of having it as a staggered approach, if that's possible.
Sure.
Okay. So we needed a motion then to direct you to talk with the city attorney's office about that?
Yes,
Okay.
you can do that, and then a second, and you can just do it by voice vote.
Okay.
And then do a review of the regulations by that point to figure out what can be amended.
Okay. Then I would move that we direct general counsel, rent control general counsel to discuss with the city attorney to ask the city attorney to present to the board what they're working through for potentially banning this software at the city council level, and also to recommend to the board any regulations that we could adjust or create to address the use of this software here in the city. Do we have a second?
I'll second that.
Okay. That's a motion by myself and seconded by Vice Chair Ivanov. And we can do a voice vote, so all in favor? Aye.
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 Any opposed? Abstentions? Okay, the measure carries. Okay, next up, we'll go back to item 12, administrative items. Both 12A and 12B are being continued until our next meeting, April 10th. So we'll move on to item 12C, the establishment of a subcommittee to address pre-tenancy construction disclosures. And Commissioner Ambrose, did you want to? Or I can, either way.
Oh, I'm fine to speak on it. So at the last meeting, we discussed, where am I? Pre-tenancy construction disclosures. So basically what this is we're talking about before someone signs a lease, having the landlord disclose to a tenant if they already know that they're in the process of, for example, building an ADU or some other type of construction that would either eliminate or significantly change a amenity, for example, parking or a storage or, for example, well, basically those two things would be the major ones, but some type of significant construction eliminating what's the word? Amenity, thank you. For that to be disclosed to the tenant. So here, we're going to establish a subcommittee so that we could discuss that further and to be able to give recommendations to our city council to move forward in addressing this issue. That's it.
Okay, yeah, I mean, I think that this is a very worthwhile thing topic to discuss. And actually, this is another topic where the city council is, I think, in my opinion, taking positive action. At the council meeting this week as well, they did direct this as part of a bigger package of different tenant protections that they're looking at. This was one that was specifically identified, I think actually because of you bringing it, Commissioner Ambrose, here out last month as a discussion item. It sort of brought this to the attention of not just our board, but also the city council that this week directed the city manager to come back. I believe this one was within 120 days with a whole range of tenant protections, including disclosure of construction at the time the tenancy begins, so that tenants know what they're getting themselves into and if they're agreeing to pay a price for amenities that may be lost. And obviously, we have a process for rent reductions if those amenities are lost, but if a landlord knows that they're about to reduce amenities, a tenant shouldn't have to go through that process, which obviously, as we know, takes many months and a lot of work. So that's a really positive development, in my opinion. And I think, actually, I'll come back around to make my further comments. But Commissioner Leslie?
So as we're discussing this and things to consider, as you're saying, the amenities being taken away, it should also be about the displacement of the tenants as well, or tenant disruption to be taken into consideration.
Yeah, go ahead.
Yeah, I think Mayor Pro Tem Terosas was also considering not just making this about pre-tenancy construction, but also during tenancy, to your point. Strengthening our protections with the means and methods forms and making sure that with are you talking about relocation?
Yeah, disruption as far as relocation, not only that, but as we've had these cases in front of us, when people do construction, not all the construction, the contractors are very neat. They'll leave nails laying around. People have had their tires punctured or, even like our small children have been injured as well. So that type of disruption should be taken into consideration.
Yeah, I think it was contemplated to consider this as a larger package with, I guess like beefing up our protections with code enforcement also, and generally with, with construction. I think that was the language they were just talking about, either not just pre, but also construction in general. If we can group that together.
Yeah, Commissioner Dudek?
Yes, and there have been issues with some tenants in terms of the notice, giving enough notice as to what's coming around the corner. In addition, and also especially when it's necessary to vacate the location or completely move out with furniture and so on and so forth, that there be enough time to just to make sure that tenants are not put into an undue stressful situation. So maybe we want to consider that too, notification.
Yeah, I would agree with that. So I think it seems there's definitely a number of things that City Council is doing that overlap quite a bit with what we've talked about in the past and also currently. And I think there's definitely some things that only the City Council can do that are outside of our authority, but that we have the expertise on the board, but especially with our staff. So it's definitely encouraging to see that the City Council is in several instances and several topics directing the city manager, city attorney, and others to consult with the rent board on these topics to get whether to get input or direct collaboration on some of the recommendations that they bring back to the City Council. I think that this subcommittee could definitely take a look at a range of topics. To me, it seems like where we have several different items or different topics that the City Council is directing their staff to coordinate with us or to communicate with us about it, I think it could be useful to have a designated subcommittee where we are sort of working on all of those issues collectively. And I know, obviously, we can only address what we have on the agenda here tonight, but I would anticipate that on future agendas here for our board, that this kind of thing could keep coming up, and potentially we could take a look at expanding the scope of the subcommittee to address those things, sort of under an umbrella of these tenant protections that City Council wants our input on in a formal way. So tonight, I think it actually might make sense for us to include the algorithmic rent price software as part of the scope of the subcommittee, along with the notice of construction and amenity loss, since both of those are obviously tenant protection issues and also both require the City Council to come to us for input. So I would propose, or at least propose conversation here tonight about combining those into the subcommittee. Commissioner Ambrose?
Yeah, I'll make a motion to combine items 14A and item 12C, to combine them.
In terms of like the scope of the subcommittee, or?
Yeah, 12C, sorry, to combine items 12C and 14A in order to establish a subcommittee with the two subjects. Is that a proper motion?
Yeah, you can do that.
Okay, so we would, so I guess we're not necessarily combining the agenda items, but I think we're combining those two topics into the
You
scope
want
of
a
the
subcommittee to
subcommittee.
cover those two topics?
Yes.
That sounds like what
Correct.
I'm hearing, and that's fine. I think you can just do that by consensus, and then if you want to form that, once the subcommittee has been formed, then you can have a motion, the subcommittee is X and X to cover what it covers.
Okay, so we have the motion. Do we have a second? The
Yes.
creation of this, okay. So we have the motion by Commissioner Ambrose and the second by Commissioner Leslie. And if we could do a voice vote on this, all in favor?
Aye.
Any opposed or abstentions? Okay, the measure carries. So now we can discuss the composition of that subcommittee and the members of it. Obviously, with our board of 5 people, with Brown Act, we can only have 2 people on the committee. So I think this is something that I would definitely be interested in serving on the committee, but obviously want to open it up to the full board to discuss. Any other interests or recommendations? Commissioner, Vice Chair Ivanov?
So I would be interested in serving on this subcommittee as well, but Commissioner Ambrose had originally introduced this item with the pre-tenancy construction that kind of kicked off this conversation. So I would defer to her if Commissioner Ambrose would like to serve on this subcommittee, but otherwise I would also be interested in serving with Chair Gonska.
Commissioner Leslie?
I think the majority of our board wants to work on this subcommittee, to be perfectly clear. I also expressed interest at the last board meeting, as soon as she mentioned, Commissioner Ambrose mentioned this, along with Commissioner Dudick. So I think all of us are gonna have to draw straws out of a hat at this point, especially when you start talking about algorithms as well. We're gonna have to get a hat or draw numbers or something to figure out who's gonna work on this.
Yeah, and I think, and just to be clear, I think we all will work on it, whether it's part of the subcommittee or not. I think these are definitely topics, as we talked about earlier with the algorithmic software, that other the city attorney may come before us to discuss it. Obviously, any action that would be taken by us, any recommendations of the city council will come before the full board. But, hearing both tonight and that everyone's interested in these topics, and just based upon discussions we've had over the course of the past year plus, I think it's very clear that all of us are interested in these topics and supportive of finding ways to strengthen tenant protection. So there's no doubt that I think all 5 of us will be very much engaged in these topics, regardless of the composition of the subcommittee. But Commissioner Ambrose?
Yeah, I think we're all interested. I think Commissioners Leslie and Dudek also expressed interest last time, so I think we're all interested. I think it's pretty standard for subcommittees also to report back each meeting, or to give reports. So I think we will be discussing, and I'll just express that I am also interested. Can I nominate myself? And well, I guess we'll just have to do rounds and rounds.
We do a motion for the 2 members. Is that how it would work?
I mean, you can do this however you want. If someone wants to make a motion for 1 or 2 people, and as Commissioner Ambrose indicated, you might have to do multiple rounds of this. Another option, because I was directed to come back to you with this algorithmic proposal at the very next meeting, you could also just wait. I mean, it sounds pretty clear what the council is going to do. The direction is to draft an ordinance to ban it. So I'm not exactly sure what the subcommittee would be doing in that short period of time. So maybe you want to put that issue, wait on that issue until after the next meeting, see if what we come up with is satisfactory to the board. That's just one way to kind of break the logjam here.
I think if we were to create a subcommittee that would allow 2 people to be able to discuss this topic outside of our board meetings, is that correct?
That's right. You discuss it with each other and do whatever work you'd want to do on that topic.
Yeah, I think we've already established the subcommittee with those, at least with those 2 elements as part of the scope, right? So now it's just a matter of figuring out who's on it. I think that's the next step, is to make a motion to either just nominate yourself, to your question, if you can do that, or to nominate both participants. If you want to do that now, you can, or we can continue to discuss.
I think she's-
Yeah, is that okay if you want to?
she's in.
Commissioner Dudek?
Yes, do you know if the city council is limiting the recommendation just to the algorithms at this time? I got the impression it was rather narrow. I don't know if it encompassed everything we're trying to talk about today.
Well, there were a number of direction from the council, and the direction included the two topics that you're talking about now.
Okay, thank you.
Commissioner Leslie?
So, as we're discussing this, I just want to make sure that, like what Allison said, as far as this will be brought back to us, as far as the scope, and will it narrow the scope or would it broaden it, is my question.
Would what, Brian?
In other words, as far as what the city council comes to us, as far as in the report, as far as would it broaden it or would it narrow it down a little bit more? Or do you not, or we're not sure?
Well, I think part of what we discussed earlier is that we need to determine if the city council directed the city attorney to consult with the board, or if they didn't, then then the action would be for Allison to request that, or to ask them to come and present to us. So it depends on which of those two things in some way. To answer your question, it would be if the city council didn't direct them to consult with us, then it would just be them giving us a report. I'm sure they would be open to hearing our feedback during that report. Whereas I think if they did direct them to consult with us on it, there would be more of a formal process they're required to do, mainly with our staff, to develop that ordinance.
Instead of
No,
working
I
with-
mean, that happens in the ordinary core. I mean, and Executive Director Holub has told me that they did in fact direct the staff to collaborate with us on the algorithmic price
Great.
software.
Okay.
But regardless of that, just, they would have done that in any event, because that's typically the relationship that we have, and they know that that's important to us. I've spoken to them about this myself. So they will come back to you with their proposal, and I'm going to come back next month and give you an update. If they're not ready with something by next month, I don't know why they wouldn't be, but it's, they have a lot on their plate. I can give the board an update on what the proposal is. I can take your feedback at that time. There are opportunities for this board to make sure that your input is included in what they're developing on this and any other topic that touches upon what you all, what your purview is.
Yeah, and those are obviously ways that would come before the full board, so everyone, regardless of who's on. the
Right,
city,
and that's obviously what what you want to prefer. You don't want information to just be limited to a couple of people. You want it to be able, as much as possible, to include the feedback of everyone. And so especially something like this, where the council is already going to do what you have said you're interested in, waiting to receive the information as a board is generally the preferred method.
Okay. If you're okay with it, I would make a motion. You're going to make a motion? Okay, Commissioner Ambrose.
I'm going to make a motion to recommend myself and Chair Gonska establishing the subcommittee.
Okay, I would second that.
You're in here twice.
Okay, we have a motion from Commissioner Ambrose and second from myself. Can we have a roll call vote, please?
Yes. Commissioner Ambrose,
Yes.
Commissioner Dudek,
Yes.
Commissioner Leslie,
Yes.
Vice Chair Ivanov,
Yes.
and Chair Gonska.
Yes.
The motion carries.
All right. I think that's everything on the agenda, right? Okay, so can we have a motion to adjourn the meeting to our next regular meeting of the Rent Control Board on April 10th? Do we have a motion? Commissioner Leslie?
Yeah, I make a motion for adjournment.
All right, do we have a
Good night.
second? Commissioner Dudek seconds. All in favor? Aye. Opposed, abstentions, hearing none, the meeting is adjourned.